Legal considerations. The law as it relates to healthcare has grown increasingly complex. Sources of law. We have constitutional law. The Constitution has 27 amendments. 10 of them are the Bill of Rights. Under this, there are 3 branches of the federal government. The executive branch, which is the president and vice president, cabinet officers, and various other departments. We have the legislative branch, which is the Senate and the House of Representatives. And we have the judicial branch, which is the courts. There's statutory law. These are laws made by the states. And we have common law, which are known as judge-made laws. Criminal law addresses wrongs committed against the welfare and the safety of society as a whole. Malfeasance is illegal conduct by an official. They're classified into basic categories: felony or misdemeanors. A felony is a serious crime and usually carries serious punishment. A misdemeanor is a lesser crime and has lesser punishment. Civil law affects relationships between 2 individuals, either corporations, government bodies, or other organizations. A term used in civil law is misfeasance, improper execution of a lawful act. Nonfeasance is failure to perform an act or official duty. In a civil case, a plaintiff brings charges against a defendant. Some common forms of civil law are administrative, contract, and tort. Some examples of administrative law would be the IRS. They enact tax laws and regulations. Medicare and Medicaid. Healthcare professionals are bound by federal administrative law through Medicare and Medicaid program rules administered by the Social Security Administration. Title VII of the Civil Rights Act of 1964 protects employees from sexual harassment. Federal Age Discrimination Act of 1967 protects employees from certain discrimination such as age, sex, race, marital status, disabilities, and sexual orientation. And then we have the Uniform Anatomical Gift Act of 1968. Constitutes that a person of sound mind may donate all or any part of their body. We have Regulation Z of the Consumer Protection Act of 1967. This is the Truth in Lending Act. It requires that an agreement by the provider and their client for payment of a medical bill in more than 4 installments must be in writing, and they must provide information on any finance charges. The Occupational Safety and Health Act of 1967, OSHA, helps to ensure a safe workplace and healthy environment. The Controlled Substance Act of 1970 regulates persons who administer, prescribe, or dispense controlled substances. It identifies controlled substances in Schedules 1 through 5 with regulations for each schedule. We also have the Americans with Disability Act of 1990, the ADA. Title I prevents discrimination in employment. Titles 2 through 4 mandate access to public services by individuals with disabilities. There's the Family Medical Leave Act, FMLA, of 1993, allows for at least 12 weeks of job protection leave for birth or adoption of a child, to care for one's own illness, or to care for a loved one who is critically ill. The Health Insurance Portability and Accountability Act of 1996, HIPAA, requires national standards for electronic health care transactions. It assists in making health care insurance more affordable and accessible when people change or lose their jobs, and it is identified in Titles 1 through 7. This law also requires the adoption of privacy and security standards to protect individuals' identifiable health information. A contract is a binding agreement between 2 or more persons. A provider has the legal obligation or duty to care for a patient under the principles of contract law. A contract exists when a patient arrives for treatment and the provider accepts the patient by providing the treatment. There's two types. Express contract. It can be written or verbal, and it specifically describes what each party in the contract will do. In a written contract, it requires that all necessary aspects of the agreement be in writing. An implied contract is indicated by action rather than words. The majority of our provider-patient contracts are implied contracts. The termination of a contract. A broken contract or a breach of contract occurs when one of the parties does not meet the obligations of the contract. A provider is legally bound to treat a patient until the patient discharges the provider formally withdraws from the patient care, or the patient no longer needs treatment and is therefore formally discharged by the provider.